Hi everyone, and I wanted to extend a warm welcome to our special guest today, Jonathan Griffiths from Griffiths Law. He's joining us today from his office here in Whitby. He's multiple offices, but today he's come to the Durham region to speak with us. Along the way, when I'm meeting clients, I meet so many people with lots of questions about real estate law and marriage and divorce, death, unfortunately all those sort of hot button topics. So lots of questions around that. So I thought, you know what, let's get an expert in and he can weigh in with his best advice. And instead of us, going to Google or ChatGPT, we can, use this as a good resource for some of those big questions we have. So welcome. Thank you so much for coming to spend some time with me today.
Thank you so much, Lisa. All of you know Lisa's a superstar.
Oh.
and we do a lot of work with Lisa's clients, and they all love her. And I can tell you from the bottom of my heart, she's a great lady.
Oh, well, thank you. That wasn't in the script, but thank you. I'll take it. Well, let's get started. I mean, we had some conversation ahead of this of what we thought would be the best things to discuss. I guess what we get asked the most. How about we start with getting older and real estate, so into our 60s, 70s, 80s, and beyond. What that looks like for how to best prepare for what life throws at us, whether that's health issues, death, unfortunately, but how that flows down to the spouse that is dealing with the real estate, with the wills. What's your first advice for married couples?
Well, it's a good idea, obviously, to have wills. Mm-hmm. Probably more important than the wills is to have powers of attorney.
Okay.
And the power of attorney, basically, there are two. One is what we call a personal care power of attorney. Mm-hmm. And I call that the pull the plug one. Okay. Where you have the right to...
Yep.
Yeah.
Okay.
And then there's another power of attorney, which is called a property power of attorney.
Okay.
And the property power of attorney essentially allows the party given the power of attorney the right to do anything except make a will for you.
Okay.
So it's pretty comprehensive. Sometimes I call it a lethal weapon because you can do a lot of damage. So you have to be careful. But if you don't have a power of attorney, then you have to go through a process with the public guardian and trustee. Right. It takes a long time. Mm-hmm. It's complicated. So you would think it automatically goes to the spouse. It doesn't.
Okay.
So, and then if you want to have that right of being, it's called guardian as to property, mm-hmm. you have to file plans as to what you're going to do with the money and the property.
Gotcha.
So it's not like I'm the spouse, mm-hmm. so please appoint me.
Right.
And then they just, oh yeah,
sign
sure.
off on
it.
Okay.
And
that's good, I guess, because you could be really harming someone at that point.
Well,
if they're hospitalized or if they have dementia or, not able to act on their own, you could be taking advantage of them.
Or if you're often the kids will pre-distribute the estate. Oh. So we see all of this stuff. Oh. So it's very important to get the power of attorney done.
Yes.
And a lot of people will leave it until it's too late.
Right.
So if somebody's really far along, then there are issues as to whether they've got the capacity to sign a power of attorney.
Okay, all right. So that's good information. So really, as soon as you have a house, that should be something that when you're signing with the lawyer for the paperwork for closing, you should be in that conversation of wills, power of attorney. Yeah. I mean, you can never be too young because God forbid something could happen, but you're prepared and everything's looked after. Yeah.
Yes,
yeah.
And it's one of these things that it's remarkably quick and simple to do, mm-hmm. but we spend years and years and years procrastinating. Mm-hmm. I used to go around doing these will seminars, and I'd ask how many people didn't have a will to raise their hands, and me too, right? So we all put it off. Mm-hmm. But if you put it off too long, you don't have capacity, then you can't do it, and mm-hmm. then you have to go through the government. So
that's not what any of us want to do. No, not. It's a hard enough situation at that moment without having to, I think, involve the hoops and hurdles of government and all of that approval. So, okay. All right. Great advice. Thank you. So another question I get asked quite often is are there any tax implications when selling my home? So most of us know that for the moment, selling our principal residence, there's no capital gains. However, many of my clients will have investment properties. They'll have cottages, where condos somewhere else in Canada. So what does that mean for the seller once especially if they're elderly? What tax implications do they have to think about?
Well, I think the main one at this stage is that if it's a principal residence, it's not taxed so far. The government's got pretty close to doing it, but they backed off. So so hopefully that's not going to happen. Now, a couple is only allowed to have one principal residence between them.
Right.
But the government's the CRA is generally fairly open-minded as to whether you use your cottage or your home. So two implications to that. One is you can likely choose.
Okay.
And the second one is that if you sell your home and you keep your cottage, the cottage can then become your principal residence.
Right.
So if you're renting in Whitby and you've got your cottage in Halliburton, the cottage then becomes the principal residence. And essentially the capital gain for tax purposes on the cottage is proportioned between how long you've owned it and how long it's been your principal residence.
Right. Okay.
And the government gives you one free bonus year.
Oh, well, that's nice
but
of
that's
them.
that's sort of the overall scheme for it.
Okay, so as soon as we sell our principal residence here in Durham,
Yeah.
then that will immediately transition the secondary property as your principal residence, and that's when the capital gains will
kick in from there.
Accrue from there. Okay, great.
Yeah.
Good. Okay, thank you. That's a great. I think that's something that everyone worries about, and there's so much mixed information online about taxes and of course investment properties. We know that that's going to be taxed at typical capital gains rate. There's not really much way we can move around that, but certainly with your principal residence, that's really good information.
And when we're talking about capital gains, it looks as if the increased rate is not going to go through. So Mr. Pierre is clear it's not going through, and
now Mr. Carney.
Mr. Carney says it's not going through.
All right.
So I think that was a big hurdle, but it looks like it's out of the way for the moment.
We can all breathe a sigh of relief. One less tax.
One less tax, but I have one other one I got to throw in.
Oh.
Sorry.
Damn.
So this is a weird one. So we'll get clients phone us up and say, oh, we got this cottage in Halliburton. We paid $500 for it. It's worth $2 million now. And we'd really like to give it to the kids, right?
Right, okay.
So the thing there is that if you give something to your kids, the government looks at it as if you sold it for fair market value. So not only do you lose your cottage, you have this huge tax bill. So that's one of the things you have to think about when you're
gifting.
When you're gifting.
Yes.
So there are various ways you can gift it a little bit at a time.
Gift one room at a time. Here's a door. Here's a window. This
guy gets the septic tank. This one gets the propane tank.
The child you don't like as much gets the septic.
Septic, yeah. So there's a little bit of tax planning there that can be useful.
Alrighty, that's good information.
So you have to be a little bit careful when you do that.
Okay, so it's not a one and done is the big message here.
This is insult to injury potentially if you don't know, right?
All right, well thank you, that's great.
Well, the other thing I got to throw in the last one is you can also lose your benefits, right?
Oh.
Because you've triggered this capital gain that you got no money for because you gave it to your kids, and now your pension stops because you made all this money, right?
Oh.
So
wow.
So there's all kinds of exciting things. If you got a cottage, you want to give it to your kids.
Well, exciting for the CRA, not
CRA,
so much for
yeah.
us. Okay.
It'll help the deficit.
Okay.
Yeah.
Well, I think the moral of this story, everybody, is consult some legal advice before having that glorious Sunday dinner with the kids, and sharing your plans. Maybe put your ducks in a row, because even with the best intentions, I mean, I'd love to do that as well, but you still have to keep going and plan for your retirement. And we're all living longer these days, so we got to be able to afford it.
So you don't want to give your cottage to the kids and then have to put a reverse mortgage on your house to pay the tax, right?
No, that would be bad.
That would be terrible.
Or just have to move in with the kids. So, there's that. So.
There's that. Yeah.
There's that. Okay, so a question for you. Many clients I'm meeting now are, say, in their 50s, and then they're buying real estate with their parents. So they're elderly parents. They're all coming together and setting that up with tenants in common or joint tenancy. So that's the two ways to own a home, can be tricky. And I think you need really good advice on that, so that the idea is usually when the elderly parents pass away, it can avoid probate and just flow right to the children. And that can be true if it's done in a certain way, and the way with tenants in common or joint tenant, or it doesn't work. So maybe you can, yes, the eyebrows, or it doesn't work. And why don't you speak to that and maybe what you've seen and your best advice on that as well?
So the parties really need to do an agreement. Because typically what I see is, if it's $1 million on the house, the parents are throwing in $500,000, and then the kids are taking out a mortgage for $500,000.
Okay.
So I see that very often, that the kids' share is being financed and the parents' is actual equity.
Right. Okay.
So they need an agreement that says if the house gets sold, that each party gets the money they put in first before the profits are split up.
Okay.
So you got to be sort of careful on that level. Then you've also got the dynamic of, often there'll be other kids, and the other kids won't be real happy if the parents end up, or if the parents die and it all goes to one kid.
Sure, yes.
So you kind of have to look at that. So what we tend to do is we'll put both parties in. So we'll put the parents in as joint tenants.
Okay.
For their share, it might be 50%, might be 60%. So if dad dies, mom gets.
Right. So that flows between one couple to the spouse.
And then you do the same for the other couple.
Okay.
So that doesn't give you like complete joint tenancy. But, everybody gets really steamed up about probate. I mean, it does slow things down, but the actual probate cost is 1.5%. So if the house is worth $1 million, it's still a lot of money. It's like $15,000.
Sure.
But it's much cheaper than litigating afterwards, because somebody doesn't think it's fair.
Right. So you're saying, in the grand scheme of things, it's better to potentially do the probate. It could be anywhere from a couple of months. To get that
2
done.
to 4 months.
2 to 4 months is the usual.
Yeah.
I know your office has pulled some rabbits out of the hat for my clients in recent days, and made that much less a fraction of that time. But that way it's done, it's set, and you can then go forward with the sale without any issue of litigation or complication later.
And it's fair to all of the parties, right?
Okay. All right. So that's really important to know. So anyone who's thinking about moving in with your family, there's going to have to be a contract. Even if there's no financing on either side, you still need to think about, should someone pass, how is this going to flow to the next person? How is this going to flow to the group as in general, and how that affects the other family? But even if there is no other family, in terms of probate, what does that look like? So I think knowing all of that up front and having it really mapped out for you when a death does happen, because again, that's such a stressful time. You don't want to be getting new information that's potentially problematic. That's going to slow you down or really put a linchpin into things. So find out these things first before getting into these agreements, and these are the people that you want to speak to. Okay, well, we're gonna jump over to a different topic. Also starts with a D, not death, this time divorce. So let's sort of get into that. I think the first place we want to start, and it might kind of seem silly, but you'd be surprised. Jonathan, what is a spouse?
There are 3 definitions of spouse that I can think of.
Okay.
Right off the bat. There's the federal government definition of spouse, which means you've been in a conjugal relationship for a year.
Okay.
So it's just 1 year. And so if you're qualifying for a first-time buyer, that sort of thing, that's what they use.
Okay.
Then in the province, there are actually 2 definitions of divorce of spouse.
Okay.
So the first definition is common law, and common law is 3 years or a relationship where there's a child.
Okay. So then with the child, there's no timeline.
No timeline.
Okay.
No. And so with that one, if you split up, you get maintenance and support rights.
Right. Yep.
Right. But you don't have any rights in a home. So there's another definition of spouse. And that definition of spouse is that you've gone through a form of marriage that you believe to be legal.
Okay.
Right?
So you have a marriage certificate.
Yes.
Okay.
Yeah. And they're always stuff like they did it in Vegas and they were drunk and all those sorts of things,
Yep.
There are always those things.
To each their own.
But the general thing, so in order to qualify as a matrimonial home, you actually have to be married.
Okay.
So and there's a lot of confusion on that.
There is, yes.
And the reason for that was there were a bunch of cases going to the Supreme Court. And they were basically ladies on the prairies who'd lived with their farmer spouses or whatever for many, many years. That the farmer dies and doesn't have a will, and the lady's out in the cold. Or, I mean, it could be the other way around, of course.
But still.
So it's out in the cold.
Yeah.
So it took several years to get to the Supreme Court. And everybody said, oh, the Supreme Court's going to say it doesn't matter whether you're married or not. And instead, the Supreme Court said it does matter. It said you either opted into this property scheme where you're married. And you get half, and you get, or you didn't. And if you didn't, all you're going to get is the support stuff. So you got to look at that first to see whether they're actually legally married, because technically, if the property's in one party's name and they're not legally married, the other party doesn't have to sign anything. They don't have automatic rights. And if they do want to make a claim, there's something called a resulting trust, where they have to show they paid to finish the basement or they paid to do the roof or...
Right, okay.
But there's no kind of conjugal overtones with that. It would be like the same a brother and sister.
Just keeping receipts and what did you pay? And so it could be roommates, just anybody.
Roommates, yes.
Okay.
Yeah.
Interesting.
So when people... And also it's the same with wills, right? If you're not legally married, you don't get the rights under wills. So whenever I say that, we get all these people coming for wills. It's always it's always the ladies, right?
Start the car.
Yeah, because the men are immortal, right? We're all immortal, so we don't have to worry with wills. But it's really a surprising thing.
Wow. Okay.
Yeah, it's shocking.
Yes.
Actually.
I think it's one of the things where people just assume the answer. They just assume that it's this way
because it's this way. because it's logical.
It's logical public
yeah.
discourse, just what they hear day to day. And it's not.
It's not,
yeah,
no.
Yeah.
So that's kind of the shocking thing. So
Okay.
that's the first thing you need to find out.
So first, identify your marital status.
Yes.
Your status has to be identified, and then you can make decisions based on that, and the two of you can decide from there. Okay.
Yeah.
Great. So let's move on to the next step in the process of divorce and selling a home. So first of all, let's assume that for this conversation that the sellers are legally married and they want a divorce. How are the profits, the proceeds from the sale of the home distributed?
Okay, so if you're legally married, it's like a business kind of.
Okay.
That what they do is it's like an opening balance sheet, and you went into the marriage with $1 million, and your husband came in with 50,000.
Okay.
Right. So then it's like an opening balance sheet. So the increase in value in your property is during the marriage is split.
Okay.
50-50.
Right. So that
But
gain.
the gain is split. But the assets you bring in, like,
are not
at their value, kind of
Okay.
fair market value when you. So if
Sure.
so that it's like that's how the general assets are. Now, the matrimonial home is totally different. So the matrimonial home, it doesn't matter where the money came from.
Okay.
It's still split 50-50.
So whether I came in with $1 and my husband came in with, $999,000, it's split $500K each to each of us.
Yeah.
Okay. All right.
So
everyone, that makes sense. So it's a 50-50 straight down the middle.
Straight down the middle. And
Yes.
I had one instance where I had a client who inherited a substantial amount of money from his mother. So he goes and he buys this big house for $1 million. This is years ago.
Yeah, I was going to say.
and he closes the deal, and then his wife says, "Hit the road, Jack," right? And so she was entitled to half of it. Whereas if it had come in as an inheritance, it wouldn't be part of the 50-50 deal.
Right. So 50-50, and I would assume unless you have a prenuptial agreement that includes real estate and a different split.
And that one is interesting too, because you can make a prenup with respect to who gets the proceeds from the sale of the house, but you can't determine who gets the possession of the house.
Okay.
So in other words, when you sign the prenup, you can't sign saying, "Oh yeah, and I'll be out in 2 weeks."
You got to go.
Right.
Okay.
So you could have this situation where you've got somebody who, let's say it's second or third marriage, the lady has a very, or let's say the gentleman has a very expensive house, the lady moves in, and the lady has children, and then the marriage goes sideways. The judge might say, "Well, I don't really want to disrupt these kids until they're 18 or until they're 20. So the lady gets the house.
Right, because she's got custody.
And it's in the best interest of the children. So the moral of the story is don't get married.
Oh, good. Jonathan. How long, for anyone watching, let me ask this. How long have you been married, sir?
Yeah.
If your wife is watching this.
I don't think she will.
Well, I'm going to send it to her.
Because there's no way around it.
No.
Like, there's no safe way around it.
No. Well, just jump in with both feet. As we, we should tell all our children, pick once, pick well. From a financial perspective, and I know that's not always the case, so I say it with all kindness in my heart, but you try your best, because it's very, very difficult to people's finances, and
it's very sad altogether. It's difficult, and I know there are circumstances that it has to happen, but there's no real good way to bulletproof the house. That's the bottom line.
Understood. That's it. There's no good way to ensure it goes perfectly smoothly.
That's right.
Yeah. Okay. So let's talk about separation agreements. Certainly, as a realtor, I hear that mentioned quite often when I'm speaking with people who are preparing to sell their home as they're going through their divorce. The separation agreement usually will contain how funds are distributed, how other things are going to be looked after in the divorce. But many times we hear that some lenders need this if, say, one of the spouses wants to go ahead and purchase another property, that mortgage broker or lender will require the both parties to be signing on that so they can see where the funds are going. I'll throw it to you, and what do you see on your side?
Well, the best thing is to have a separation agreement.
Okay, so that's number one.
Absolutely.
Okay.
Because if you don't, even if they've got some sort of an oral arrangement, particularly if one party's trying to buy a home the same day with the proceeds, then it totally gives the other party the power to
say no.
Or to get a deal they really shouldn't because they're up against the wall.
Right, and I have seen that happen. It's very, very stressful.
It's totally stressful because the night before closing, either of the matrimonial lawyers can write a letter saying don't release the funds. And then we've got tons of money that just sits there.
And you can't touch it.
You can't touch it. Neither party can.
Gotcha. Okay. Yeah. Okay, so have that separation agreement in place. It'll give you the peace of mind, and it'll give you the ability to move forward after your matrimonial home is sold, and you can then purchase something to move forward to. And especially as, a lot of us have kids, that's important to have, where are we going next? All the ducks are lined up, and this is a really big piece of that puzzle.
Right. So there's one unexpected complication.
Okay. I feel like I should put my seatbelt on and strap in for this.
And that is that sometimes, particularly if there are children, one party wants to close before the sale happens.
Yes.
So they'll go into the bank and the bank will smile at them and say, yes, we'll give you bridge financing. And then somebody in the bank wakes up and says, no, in order to get bridge financing, we need both spouses to sign.
Right.
Because they both own the house where the proceeds are coming from to pay back. So that can be a very difficult position. So if you're going to do that, you better make sure that both parties will sign.
Gotcha. Okay. So if bridging can be difficult, we can think about either closing on the same day, so closing your sale and then your purchase, or the other option is just to have a little wee gap.
Yes.
Sometimes just storing your furniture on a truck, paying them overnight or 2 nights can be worth not having the headache or that panic of what if it all doesn't line up, especially when we have children moving with us. That can be I think a bit more seamless. I've seen that as well, and certainly from a financing perspective, that might be the easier way to go. Yeah, so definitely talk with that about that process with your realtor, and really try to figure out the smoothest way forward. Because I think, in my experience, when we're selling through a divorce, really what becomes so important, obviously, the highest sale price because we're splitting that equity in half. The next really important thing is just keeping things, I think, as stress-free as possible. It's really tough. So knowing where we're going to land, knowing where we're going to move into, all of those things can ease the stress. Having it all lined up and really planned out properly can make a world of difference. And your real estate agent should be able to help you with this. Don't just assume that you have to buy and sell on the same day, because that's not the case. There's other options there for you. All right, well, thank you. That really, I think, answers some big burning questions many people I meet have had. I know I get lots of questions from people emailing in, texting in, seeing our videos and asking these questions. So that's one of the reasons I wanted to have you aboard, and I really appreciate your time. And
thanks for having me.
Yeah, and I love just sort of that lightheartedness you bring to it, because it can be a really hard conversations, and to have I think someone there's with a bit of levity and just you know so much, and it's such a valuable resource. So whoever you choose wisely, and I didn't mean for the spouse, I mean for your lawyer. In this case, you really want to make sure that you have someone who is on your side in your court, because it will make all of the difference throughout the process, on the day of closing and beyond. That would be my little 2 cents of advice for you. So again, I wanted to extend a big thank you to you, Jonathan. So Jonathan Griffiths from Griffiths Law Firm. You can find him here locally in Whitby, also at Port Union and another office downtown. So wherever you are, they can certainly look after you and anything that you need regarding wills, anything to do with real estate. They're a fantastic firm to call, and I really do highly recommend them. So thanks again for joining us and spending some time with us.
Thanks so much for having me. It's great.
All right, everyone, thanks again, and I hope to see you all next time. And if you have any questions, if this has sort of raised any, I wonder about this, please just give us a call. We'll be happy to answer what we can, and if not, point you in this lovely gentleman's direction. All right, have a great day. Thanks again.